Yes.
My Lady, my Lords, we were on issue 2, and I was addressing the court about the common law approach to whether something's a variation or not. I had identified the points of principle. I was going to say something next about the authorities. Now, I don't have time to take your lordship and your ladyship through the authorities, but I would just say this. We have identified, I think, 9 authorities, most of them Privy Council or House of Lords, which articulate very clearly, in most cases, that the test is one of intention. And I ought to be clear, we do not say, I think I've said this already, that whether there is a substantial change, material change, going to the root of the contract is irrelevant. It is one of the factors that you have regard to when you're considering the question of intention. And the issue between us, in a sense maybe between us and the Court of Appeal as well, is whether that's the only factor. Do you simply look at the terms of the contract and say there's been a material fundamental change that goes to the root of the contract, therefore whatever the intention of the parties, it is a rescission, or is that simply one of the factors you look at when you consider the question of intention, that being a question which you determine by reference to all the circumstances of the case. And that's all we're saying, that A, the test is one of intention, B, therefore there isn't a 2-stage test, there's only a 1-stage test, C, if parties have expressly stated their intention, that will get a great deal of weight. It may not be always conclusive, but it will usually be conclusive. D, among the factors which are relevant in considering intention is whether the change goes to the root of the case, but in and of itself, that's simply a factor, can be a very important factor, particularly when there are no other circumstances to look at. But E, that is not the only exclusive factor you look at. You do have regard to anything else which bears on the objective intention of the parties. And in our respectful submission, that submission as to what the English common law says in determining whether something is a variation or a rescission is borne out by all the authorities in this jurisdiction. And I include in that the following 9. As I say, they're either Supreme Court, House of Lords, House of Lords, or Privy Council, with a few exceptions. Morris, Bennington's, Shukar, I'm going to have to come back to Shukar, that's Lord Devlin, I think it was Privy Council. The first 2 were House of Lords. Sukraj, that's Lord Scott in the Privy Council. The relevant passage is cited by Lord Justice Lewison. Lord Justice Toulson in Wadlow, again refers to the test as being one of intention. Lord Justice Elias in the Dow case, which I may just take your lordships and your ladyship to briefly. He was sitting in the Employment Appeal Tribunal. Lord Sumption in Pleven, Supreme Court. Mrs. Justice Slade in Potter, and Lord Justice Lewis in Cox, very recently in the Court of Appeal. Now, we've given references for all of these, and if I had time, I would take you through them, but I don't. I think if I may just take you very briefly just to the employment cases. I'm going to show your ladyship and your lordship 2 short passages, because in our respectful submission they very clearly state the correct approach. The first is Dow, which is page 1098. It's Primary Authorities B8, tab 8, page 1098. I identified this morning the sort of case that this is. It's an employment case where, because there was an issue in respect of the Equality Act, or the Equal Opportunities Act, there was a limitation period of, I think, 6 months from the date of termination of the relevant contract and that gave rise to a debate as to whether, in relation to contracts which had been varied, the effect of the variation was to rescind the previous contract so that the time would run from the date of the variation, or whether it was simply to vary. Some of these contracts actually had express variation clauses in them. If I can just invite the court to go first to page 1102 in the judgment of Lord Justice Elias, just look at paragraph 36. So 1102. The task in each case is to determine the intention of the parties. This involves establishing whether there is evidence objectively to show that there is an agreement as to the mechanism to be adopted. If the change is not of a fundamental nature, the only proper inference is that there was a variation, unless we are satisfied that there was objectively viewed an express agreement that the mechanism to be adopted was the termination and the new contract route. And if I can then invite you to look at the next paragraph. In determining that issue, the reasoning of the majority is as follows. First, in our judgment, where there is clear evidence that both parties have signed what is stated in terms to be a new contract, that is conclusive evidence that the termination route has been chosen. We do not accept that other factors can detract from the plain language of the agreement. That was the position of Ms. Slack. And then if I can just also invite the court to look at paragraph 24, previous page, page 1101. The majority, President Elias and Mrs. Gallico, agree with Mr. Jeans that where it is clear from the contractual documents that the parties have agreed to effect changes by a fresh contract, that must be decisive. The courts must give effect to their chosen mechanism. And then if I can very briefly show the court also Potter.
So I'm sorry, just which paragraph was that?
Paragraph 24 on page 1101, left-hand side. About
one needs to read the whole of 24, though, doesn't one?
Sorry.
Okay. However...
I don't need to read it out, one needs to take it in.
Indeed. And then if I can invite the court next to go to Potter at page 1296. So Primary Authorities Bundle 1296. For this, if you go to, if I can invite you please to go to page 1305, paragraph 72. This is Mrs. Justice Slade. Fundamental as well as minor contractual changes can be affected by consensual variation. Parties can agree both the content and the mechanism for effecting contractual change. Such agreement may be express or implied and will be the best evidence of their intention. If parties agree that the mechanism for contractual change, the degree or fundamentality of such change does not determine whether it takes effect by rescission and replacement with a new contract or by a variation of an existing contract. Where parties do not expressly agree the mechanism for a change in terms and conditions of employment, their intention in this regard is to be objectively ascertained from all the relevant circumstances. If the only evidence of intention of the parties is the degree of change, in our judgment there will be no difference in practice between the approach of Mr. Allen of considering intention and degree of change together, and the two-stage approach contended for by Mr. Supperstone, in which the degree of change is only considered if the intention of the parties cannot be ascertained. The approach of Mr. Clark is, in our judgment, the correct one to adopt only if, in all the circumstances, the degree of change is the most significant evidence of the intention of the parties as to the mechanism for change. Where terms and conditions are fundamentally changed in the absence of indications to the contrary, the inferred intention of the parties is likely to be to terminate the old contract. And that, again, in our respectful submission, reflects the summary of the position that I sought to give the court some moments ago. And it also, in my respectful submission, reflects the earlier authorities, which I don't have time to take you through, and I apologise for that.
And I think the statutory context for this decision was the same as in Dow.
It was, yes. If I'm right about the test being one of intention, as the upper tribunal found, not a two-stage test. In other words, if it's not all determined by asking about the reason, that obviously still leaves the question of, well, what was objectively ascertained the intention of the parties here? And that's the point, if I may, that I'd like to go on to address next. And for this purpose, can I invite the tribunal to look at what the upper tribunal said about this? Because, of course, the Court of Appeal adopted, some of them adopted what appears to have been a different approach. So it is helpful to look at the upper tribunal. That's at page 162 of the key documents bundle. Behind, if you're looking at hard copy, tab 6. So I think I may have said 162, page 182, I'm sorry. So we started paragraph 106.
Sorry, were you on 152 or 132? What page are we on?
Page 182.
182? Oh, goodness, I'm sorry, I misheard you.
Paragraph 106.
Yeah, okay.
This is paragraph 106, yes.
106. And this is the upper tribunal
Got it.
applying the intention test. Applying the test based on the parties' intention, we are no doubt that they intended the change orders only to vary the golden contract, not to rescind it. This case is far from the type of case referred to by Lord Justice Tilson in Samler and Wadlow, where the parties do not turn their minds to the somewhat legalistic question of whether or not a variation is intended to rescind the original agreement. Viewed objectively, the parties to the golden contract clearly intended that the contract to preserve the entitlement for someone to claim EZAs on construction expenditure on the site. The change orders were similarly intended to result in a building being constructed that was somewhat different from those provided in the golden form in the golden contract, but for EZAs nevertheless still to be available on the cost of the construction. Mr. Williamson QC was correct to submit that the parties' common desire to ensure that EZAs would be available to the purchaser of the building ultimately constructed is strong evidence of a common intention that the change orders would not result in rescission. And if I can invite you next to look at paragraph 107. Mr. Cosman argued, he was for the commissioners, that this reasoning results in primacy being given to the parties' subjective intentions, particularly since neither the golden contract nor the change orders refer in terms to CAA 2001 or tax benefits that were hoped to arise. We do not agree. At all material times, the developer and contractor were under common control. As we found at paragraph 33, the golden contract was entered into as part of the arrangement specifically designed to ensure that EZAs could still be claimed on construction expenditure at the site. The expectation that EZAs would continue was not simply an unexpressed subjective wish, or as Mr. Cosman put it in his submissions, a contemporaneous hope of the parties. On the contrary, the desired tax benefits informed the willingness of the developer and the contractor to be party to that contract, and also informed their common approach to changes to it. In those circumstances, the desire for construction expenditure to qualify for EZAs was a common goal shared by the developer and the contractor, and is thus directly relevant to the objective ascertainment of their intentions. That is the case even though the parties did not refer expressly to the EZAs in the golden contract or to the change order. And if I can then just invite the court to look at paragraph 108, where the upper tribunal dealt with a number of the factual points made by the commissioners, which again the commissioners seek to make before this court. I wasn't going to read all of 108, but if I can just take the court through 108, 1 and 2. Works option 1 set out in the original golden contract envisaged the construction of a facility for the manufacture of microchips, whereas ultimately the contractor built 2 data centers. However, while the contractor built different buildings from those originally envisaged by work option 1, we accept Mr. Pulford's evidence that from a construction perspective, the differences were not significant. To build the data centers, the contractor used broadly the same subcontractors it would have used to build the microchip facility, the principal difference being that to build the microchip facility, the contractor would have needed to engage fluid handling subcontractors, but did not need to do so in order to build the data centers. Otherwise, constructing the data centers involved broadly similar skills and expertise to those that would have been involved in building the microchip facility. And then 2, Works option 1, as set out in the original Golden contract, envisaged that the microchip facility would be built on Site C. However, while the data centres were built on the Cobalt Business Park and in the vicinity of Site C, they were not actually built on Site C, largely because by this time DC2 and DC3 were constructed. DC1 was already present on Site C. We accept Mr. Pulford's evidence that ultimately DC2 and DC3 were built around 20 metres from Site C, and accept his description of this change as not being a big deal. And then at 109, over the page, Appellants Tribunal said, in our judgment, having identified further differences, none of those differences, whether individually or together, was inconsistent with the parties having a common intention that the Golden contract should be amended as opposed to be rescinded. Now,
Just on a very small point of detail, in 1081, the Upper Tribunal says that ultimately the contractor built 2 data centres. Did it actually build 3 data centres?
it built DC3.
1, 2 and 3.
DC3 as well, correct.
Yeah.
I think DC3 didn't feature in this case, but ultimately that's the position. Now, my lady, my lords, we were, as the court knows, not involved in this case in the Upper Tribunal or indeed in the Court of Appeal, but it did strike us that the factual points were neatly encapsulated, if we may respectfully say so, by an observation made by Mr. Justice Zaccaroli in the course of argument. He expressed the view that the parties would have been, in these words, that the parties would have been mad to intend anything other than to vary the Golden contract, because they knew, both subjectively and objectively, that the tax allowances which the Golden contract was designed to preserve would be lost if Change Order 2 took effect as a new contract rather than as a variation. Just for the court's note, that's a transcript, page 1032. It's on internal page 57, lines 3 to 12.
Was amendment versus rescission treated as being the only way of looking at the issue by consent of the parties before the Upper Tribunal? And one could think of not necessarily amendment versus rescission, but amendment versus leaving the old contract there to do what it still had to do and supplementing it with another one.
Which is, of course, what was considered by the Court of Appeal.
Yes.
Yeah.
I just wondered whether, in the first instance, it was being looked at in this rather primary colours way.
If you look at paragraph 112 on page 184,
Yeah.
Contract.
you can see that that was considered. And also paragraph 120.
Yes, I'm sorry, so it was put as an alternative way of looking at it.
So we respectfully say that Mr. Justice Zaccaroli's comment that the parties would have been mad to intend anything other than to vary the Golden contract, albeit an informal way of putting it, was, in our respectful submission, an entirely accurate way of putting it. But of course, the Court of Appeal rejected the conclusion reached by the Upper Tribunal, in part at least because of the different approach they took to how you test for variations. That's to say, 2 stages rather than just a question of intention. And I've already made submissions on that. There is only 1 stage, and the question is what the parties intended. And if one asks that question, having regard to the tax context, which, again, Lord Justice New accepted was relevant, in our respectful submission, there really is only one answer, which is that in circumstances where the parties understood both subjectively and objectively that the tax allowances which the Golden contract was designed to secure would be lost if DC2 was to be built pursuant to a new contract rather than a variation.
The oddity is that they didn't intend to vary the contract, because they actually did this under Clause 12.
With respect, your Lordship says they didn't intend to vary the contract. Your Lordship is right. They didn't intend to vary the contract. What they definitely intended to do was a variation. but they thought they were varying.
They intended to change.
No, that's your lordship is right. They thought they had a contractual. In a sense, one is in a similar position. If I can get to this point now, to the situation where a party seeks to terminate a contract, thinking that it has a contractual right to do so, and it turns out he doesn't have a contract, or she doesn't have a contractual right to do so. The way the law rather than the court approaches that is to say that unless there is some inconsistency between the way in which they've sought to terminate under the contract, the law will still give effect to their intention to terminate if they have an entitled to terminate at common law. And in a way, that's how we respectfully submit that one should be approaching this. It is true to say that they plainly intended to vary. They thought they could vary under the contract. Turns out they were wrong, if I'm wrong on issue 1. The question is, what do you do then? Do you just say, oh, well, there you go, bad luck, a mistake? Or do you actually say, that would be the most unattractive conclusion to come to in circumstances where hundreds of millions of pounds are being invested, where a contractor needs to know that he has some contractual basis for doing what he's doing, and indeed he's happy to do it under the contract, and indeed does do it under the contract? Does the court say, well, sorry, chap, you were wrong, no contract, all a terrible misunderstanding, you have no legal contractual rights or any obligations? Or does one, and I'm going to come to a case called Shukar, which I've mentioned before, does one say, in circumstances where the parties cannot achieve what they intended to achieve, the role of the court, or indeed the law, is to seek to give effect what they were most likely to have intended to achieve, even though the mechanism they chose was wrong?
Well, they chose a mechanism which would demonstrate the lack of an intention to terminate the contract or indeed make a new contract.
With respect, your lordship is exactly right. And what they plainly wanted to do was vary. Plainly didn't want to, we know that they didn't want a new contract because both subjectively and objectively that would have been a disaster for the purposes of the tax position.
And is the point against you, or are you going to say, well, they mistakenly understood the position, but might it be said against you that if they really wanted to vary this, why didn't they do what they did with the first 2 variation agreements?
Well, that may be said against them.
By an express variation.
Because they thought that they could vary under the contract, and they were wrong. The question is, do you then just say, too bad, you're wrong, no contract? Or do you say, in circumstances where there's plainly an intention to vary, they thought they had a contractual right and they didn't, but we know the intention was to vary. We know the contractor was very happy with the variation. I'm going to come to clause 4.2, because the contractor, and this is not in dispute, thereafter acted as if the contract was there and complied with the contract. You don't have a no contract situation, you have a contract of variation, because that's plainly what they intended. And they really needed to have intended that, because as the learned judge said in the upper tribunal, they would have been mad to intend anything else. And that in the end is of course the basis upon which the upper tribunal decided this. I need, I think then, so that is our primary submission. What matters is intention, and you have the relevant intention. And if you get away from the 2-stage approach, there doesn't seem to be another answer. And indeed, even if you have regard to the root of the contract, as the upper tribunal found, as the court saw, in paragraphs 108, I think in particular, the extent of the changes were not significant. I'm not saying that there wasn't, they were building a building which could fit into a different description, but you've seen the evidence at the finding at 101.1 and 108.1 and 182, which are not challenged.
What has happened actually as far as DC1 is concerned? Has tax relief been obtained?
That's a very interesting question. I believe has it been paid? It's sitting behind our application, apparently, so not yet. Yeah.
I mean, the circumstances are rather different of DC1, or they may be.
I'll come on to that. If the revenue are right, then they may not be that different,
right,
actually. I need then to just deal with 3 points which have been made. either by the Court of Appeal or by my learned friends, certainly considered by Lord Justice Lewison as being relevant to the conclusion. Now, in our respectful submission, it's not clear where these points go. It's not clear whether they go to intention or whether they go to a second stage where things happen and you look at things and you say, I don't care what you intend because of exhaustion. I'll come to exhaustion because the exhaustion of the remedy or spending the remedy. There's a reference to the SDA contract, which I need to pick up again. It's not clear what that goes to. But let me deal with them rather than just talk about them. We don't know where they fit in. Can I deal with it in the following order? The first point is the no contract point. Now, the court will recall that the no contract point was a point that Lord Justice Newey floated as being a possibility on the basis of Beazley and Glencore and cases like that, where parties intend something, when parties do something thinking they have a contractual right to do it, and they don't, then the conclusion can be that there is no contract. Because they thought they were exercising an existing contract right, they weren't intending to make a new contract. And although Lord Justice Newey floats this, in the end, he doesn't decide here that there is no contract. So he floats it as a possibility, but in the end he's persuaded that there is a contract. And indeed a contract, well, between these parties, but it's a new contract. But I need to deal with the no contract point because my learned friends still rely on it. Let me add some bones to it. Just to say, we deal with it in our note at paragraph 1151 and following. I think we deal with it relatively shortly. My learned friends deal with it at paragraph 105 of their note, that's page 100. And I'll deal with it in a minute why we say it's wrong. But can I just make these points, introductory points? It's worth identifying, I think, at the outset what the consequences would be if the no contract conclusion analysis is right. The consequence would be, first, that a substantial and complex construction project that lasted for over 10 years was undertaken without any contract at all. Secondly, that although change order 2 provided that the contractor would be paid £54 million for the construction of DC2, the contractor in fact had no contractual entitlement to that sum.
Can I just, paragraph 139 in the Court of Appeal, Lord Justice Newey says, it has nonetheless been common ground between the parties that DC2 and DC3 were built pursuant to contracts between the developer and the contractor.
Yeah.
I'm not quite clear why you need to deal with the no contract point.
Well, because your lordships are not, because now they're saying there is no contract.
Despite it being common ground that there was.
Indeed. I'm very happy to pass over this because it's complicated.
I hadn't.
It is complicated, although quite interesting. But they certainly, before the Court of Appeal, said it was common ground. I think what they wanted to say was that it was the SDA.
Yes, they did.
Which seems obviously wrong for reasons I'll come to. Can I just, I'll try and deal with it shortly. No, your Lordship is right, but I'm in a position where I don't know whether your Lordship's going to be happy to entertain points, whatever the position was below. And your Ladyship as well, and I therefore need to deal with these points, but if I don't need to, I won't. So the first point, as I say, is you would have a substantial and complex construction project that lasted for over 10 years, which would have been without any contract at all. Secondly, that although change order 2 provided that the contractor would be paid £54 million for the construction of DC2, the contractor in fact had no contractual entitlement to that sum and would instead have to sue for unjust enrichment to obtain remuneration. And third, that the developer in fact had no contractual entitlement to the construction of DC2 in accordance with the specification of change order 2. So if the contractor delivered the wrong type of data center or built DC2 defectively, causing loss to the developer would be unable to sue for damages. That would be the consequences. Now, if the law dictates those consequences, then so be it. But in our respectful submission, The law would only find that as a consequence if there were no other way to deal with this, because it really would be a conclusion of last resort. And in our respectful submission, it certainly would be inconsistent with what the parties plainly intended to happen, and indeed inconsistent with the way they subsequently operated, where, as I say, both sides operated on the basis that there was a contract, and indeed it was the golden contract. Can I just identify two reasons why we respectfully submit that the court is not forced to go to that conclusion? And the first is, as I think I've indicated already, foreshadowed, it's contrary to the guidance given by Lord Devlin in the Shukow case. Can I just take your lordships and your ladyship to this authority? It's at page 1401, Primary Authorities, tab 18. If I can just summarise the facts. The facts are fairly straightforward. It's, as you can see in the Privy Council, there was an agreement of loan for £55,000 under a written contract. The interest rate was 9%. The parties subsequently agreed to vary that, done by way of a notification and then an agreement. They agreed to vary that, and so the borrowing rate would be the interest rate would be 11% rather than 9%. So a contract of loan originally with 9%, amended by agreement to be 11%. The amendment was invalid and could not be given. It was unenforceable. Didn't comply with certain relevant formal requirements. The argument that was made by the borrower was that the effect of the variation was to bring about the rescission of the contract of loan. In other words, there was therefore no contract under which money was lent, and this was rejected by the Privy Council, unsurprisingly. There are, we respectfully submit, two passages in the judgment of Lord Devlin that are of some assistance in relation to the no contract point. And if I can invite the court to go, please, to page 1408.
And can I just check, what would have been the consequence if there had been a variation of the contract of loan?
It would have been 11% rather than 9%.
Right.
So the only thing that the variation was intended to do was to change the interest rate.
If there'd been a rescission of the...
There would have been no contract under which the borrower...
So would they have been entitled, would the person that had lent the money be entitled to recover it back immediately?
By unjust enrichment, but possibly.
Right, but the court didn't go into that.
They didn't go to that because they didn't need to. This was also 1968, so I can't remember what the law of unjust enrichment was then. Lord Burrows will, I'm sure, remember. If one goes to 1408, just picking this up at the letter F, just perhaps looking at the letter E, the court sees the sentence, since, however, the real contract is not evidenced in the way required by the money lending law, it cannot be enforced. Okay? And the court sees the reference to the real contract, since the real contract is not evidenced in the way. The real contract was that it should be at 11%, but they couldn't achieve that. And then if we go down to F, another way of arriving at the same result is to treat a variation of a contract as something that necessarily requires the rescission of the old contract and the substitution of a new one. On this view, the old contract cannot be enforced because it has been rescinded, and the new contract cannot be enforced because it is not properly evidenced. This was the conclusion reached by the Divisional Court in Williams and Moss Empires and adopted by the Court of Appeal in Morris and Barron. As Mr. Justice Sankey put it in the former case, the result of varying the terms of an existing contract is to produce not the original contract with a variation, but a new and different contract. And then we have this. The disadvantage of this view is that a minor variation may destroy the effect of the whole of the transaction between the parties. The alternative view, adopted by the House of Lords in Morris and Barron, and again in British and Bennington's and Kachar, where Lord Sumner referred to the former view as possibly correct as a matter of formal logic, is based on the intention of the parties. They cannot have that which presumably they wanted, that is, the old agreement as amended, so the court has to make up its mind which comes nearer to their intention, to leave them with an unamended agreement or without any agreement at all. And, my lady, my lords, what we respectfully submit Shukar demonstrates is that where the agreement the parties seek to make is ineffective, the court does not simply say that there is no contract at all, but what it does instead, if, to use Lord Devlin's words, they cannot have that which they presumably wanted, what the law does, is to give effect to whatever solution which, again, using Lord Devlin's words, comes nearer to their intention. Indeed, my lady, my lords, the contrasting outcomes in Morris and Bennington's and Shukar well illustrate the point. In all three cases, what the parties actually wanted was a varied agreement, but they couldn't get what they actually wanted because of particular statutes which prevented the enforceability of the variation. So they couldn't get the actual agreement they wanted. As Lord Devlin put it at page 1408E, the original unvaried contract was no longer the real contract between the parties because they had attempted to vary it, albeit unsuccessfully. In all three cases, the court asked the question, given that they cannot have the varied agreement, what comes closer to their intentions? No contract at all, or the original unvaried contract? In Morris, the answer was the former, no contract at all. But in Bennington's and Shukar, the answer was the latter, the original unvaried contract. And if, my lady and my lords, were to ask the same question in this case, what comes closer to what the parties intended, if they cannot have what they wanted, namely a variation under clause 12, the answer we would respectfully submit is clear. It is a variation at common law, and certainly not no contract at all. The second point I was going to make related to the analogy to termination, where you think you're terminating under a contractual right, turns out you're not. The court will treat that as an attempt to terminate at common law and give effect to it. And that's what we respectfully submit is the position here. So that's all I was going to say on the no contract point. The second of the points I need to deal with is the exhaustion point. And to some extent we've covered the ground here, but in a different context. Just for the court's note, we deal with this at paragraph 114 and following of our case, and that is at page 51 of the key documents bundle. Now, in order to explain the exhaustion point, can I take the court back, please, to change order number 1, which for the court's note is at page 648. For those who are working from hard copy, call to behind tab 15. So it's page 648. I'm taking the court to change order 1 because this is the relevant change order in the context of the exhaustion or spent point. As the court knows, this is not the change order which is directly before the court, but it is common ground that on the 20th of November 2009, the developer issued change order 1 requiring the contractor to build a data center on site C, and that is recorded paragraph 12 of the statement of facts and issue. In the Court of Appeal, a point arose out of this. It wasn't a pleaded point, and indeed it hadn't been run below, it arose in the course of argument, namely that the golden contract was, as it was put, spent or exhausted by the issuing of change order number 1 in 2009. And the consequence of that was said to be that change order 2 could not have been a variation of the golden contract. Now, that contention was accepted by Lord Justice Lewison at paragraph 69 of his judgment. That's at page 132 is the key document bundle. I wonder if we can just turn that up.
Which paragraph?
Paragraph 69, page 132. So, in my judgment, it is necessary as a preliminary to consider the effect of change order 1 and the construction of DC1. As noted, the golden contract as originally drafted gave the developer the right or obligation to proceed with only one of the various draft-defined works options. The second variation agreement entitled the developer to proceed with both work option 1 and work option 3, but it didn't alter the developer's essential right to proceed with only one project, or in the case of works options 1 and 3, 2 projects. The developer exercised that right by issuing change order 1, and DC1 was duly constructed. Neither the golden contract as originally drafted nor the golden contract as varied by the variation agreements permitted the developer to exercise the right more than once, let alone more than once in relation to the same works option. The effect of issuing change order 1 and its implementation, in my judgment, was that the developer's right to require works option under the golden contract, other than in accordance with clause 12, was spent. So that's where you get the exhaustion of the rights or the spending of the rights. Now, my lady, my lords, we respectfully submit that this is wrong, and there are 3 reasons why that is so. The first point is this.
Lord Justice Newey said much the same, did he not?
Lord Justice Newey dealt with it in a different way.
Okay.
I can tell. I'll tell you now, and then I'll deal with this because it's relevant. Lord Justice Newey. So what Lord Justice Lewison seems to do.
I would find it helpful if you just tell us why Lord Justice Lewison is wrong.
Was wrong.
And then go to Lord Justice Newey.
Yes.
First, I said there were 3 reasons, and these are they. There is or may be a false premise that underlies Lord Justice Lewison's reasoning at paragraph 69. As the court will recall, if you look at paragraph 69 in the final sentence, what Lord Justice Lewison said was that the change order 2 could not have been a variation of the golden contract because the developer's rights under the golden contract were spent. And he appears to have proceeded on the basis not only that a contractual right to have a particular works option had been issued or served, but indeed that it had been implemented, duly constructed, etc. But with respect to halfway through, the developer exercised that right by issuing and DC1 was duly constructed, and then later on he says the effect of issuing change order 1 and its implementation, etc.
So I'm not quite sure where you're getting the it's been implemented by construction as being critical to the reasoning.
Well, in a way,
It seems to say there's one right to exercise an option, it's been exercised.
so there are 2 ways in which this point arises. Lord Justice Newey deployed it in one way. Lord Justice Lewison may have deployed it in the other way. One way in which the point arises is to say, when I've exercised a contractual right and you have completed the work in relation to that, there is after that no scope for a variation, because in a sense the contract has been spent, your right has been spent, everything that has been done, and Lord Justice Lewison seems to say as a matter of law you just can't vary it. The other way of approaching this, which I think is closer to what Lord Justice Newey said, and there's also a hint of this in Lord Justice Lewison, but is to say as soon as I exercise that contractual right to choose something, the right is spent and I can't vary it. In our respectful submission, both are wrong. I'm trying to deal with why both are wrong. Certainly, if anyone is relying on implementation, that's to say completion of the works, as being relevant to the reasoning, so it's a stronger case, if you like, than just saying, please do X rather than Y, because they've done X rather than Y. One can quite see why then. You may say, well, it's quite hard to vary. You may have been to Paris in the example that Lord Richards gives me. One can quite see why someone may say, well, it's more difficult to see how you can vary when everything's been done. But if that is the way in which Lord Justice Lewison was seeing that, then with respect, it is based on a false premise. And the false premise is that the work had been completed, because it hadn't. If I can invite the courts to look at...
Sorry, I think that's what I was slightly questioning. Okay. You might be right that Lord Justice knew he does it slightly differently, but just looking at paragraph 69, I mean, it seems that Lord Justice Lewison is talking in terms, actually, of exercise of a right. You have the opportunity to exercise a right. It's been exercised.
Therefore, you can't
the right is spent.
Okay. Would if, in my respectful submission, that as a proposition, with respect to the learned Lord Justices, is wrong.
Right, yeah. I'm waiting for the argument, just to identify what Lord Justice Lewison was saying.
So if that, indeed, and I'll come to that if I may, but can I just deal with the stronger form of it, which is based upon not only the right being exercised, but actually all the work having been done. That is, with respect, factually incorrect. If you go back to change order number 1, which you may still have open at page 648, the court will see, first, in the second paragraph, what is required by this is undertake the design, construction and commissioning. So certainly what the change order required was completing all the work, including the fit-out work of the construction. Secondly, if you look at the third paragraph, you see that the total sum payable is 62 odd million, which amount shall be on account of the contract sum as stated, of which 13 million relates to the shell and core, and 48 million relates to the fitting out work. Now, the only part which had been concluded was the shell and core. The fit-out work, which were essential works to be concluded before a tenant could actually occupy the building, had not even commenced, and that is for 2/3 of the value of the work.
By April 2011.
By April 2011. And I've laboured this point, and I'm sorry because I've tried to deal with 2 points at the same time. The short point we make is that to the extent that this point depended upon an understanding that the work had been concluded, it was with respect wrong. Because 1/3 in terms of value of the work had been done, the shell and core had been done, the fit-out works, which were 2/3 of the value, had not been done.
That's just a factual assertion, but it's not in dispute, is it?
It's not in dispute. There is a minor dispute, which we'll see if my learned friends develop, as to whether the fit-out works were a requirement of the golden contract. There is no dispute as to what works were done and what weren't done, as I understand it. Of course, if there is a dispute, and there is a factual issue, that is because of the way in which this arose, where it wasn't a pleaded point. But I don't understand this to be a dispute. What is that? Okay. So that is, in a sense, a reason why the first, stronger form of the argument doesn't work. The second point that we make is this, and it relates what appears to be a tension in the Commissioner's case. It arises in the following way. The premise upon which the exhaustion point depends is, of course, that Change Order 1 was itself issued under the golden contract, such that the developer's rights to have anything built under the golden contract were exhausted in 2009. And if that is wrong, that is to say, if Change Order 1 was not itself issued under the golden contract, then it must follow that the exhaustion point simply doesn't get off the ground, because there wasn't any valid contractual exercise of the right. The way in which that contractual exercise of the right is set to been given shape is by change order 1. But if change order 1 wasn't a contractual exercise of the right, then, or a right exercised under the contract, then this point doesn't get off the ground.
Sorry, I'm not quite following this because...
Are you about to tell us why it's...
Well, because that was issued by way of a variation under clause 12.1.1. And if my learned friends are right in what they say about clause 12.1.1, change order, which is to say, this was for a data center. In other words, this also wasn't for something which built 8-inch boards. It was for a data center. And if they're right about clause 12.1.1 not applying to change order 2, then the same vice affects change order 1, because it was outside of the contract, outside of the unilateral variation right under the contract, and therefore whatever was agreed, if they are right, would not have been the exercise of a contractual right under the golden contract.
I understood the argument to be that there's a contract that sets up various works options, then varied to include more than one of those options, so for these purposes 1 and 3. Mm-hmm. Everything that you might say has been one would expect to have been dealt with has been dealt with as regards works option 1. As I understand the argument, therefore works option 1 has been exhausted and the contract doesn't permit.
Well, again, that's with respect an error, because if we're talking about change orders rather than works option, change order 1 involved a variation of what the contract identified as works option 1 and works option 3 in exactly the same way as change order 2 involves something which is different to works option 1 and works option 3. If my learned friends are right about change order 2 not being within the contract, then exactly the same point applies to change order 1.
And vice versa.
And vice versa.
I don't quite know where this argument's getting you.
Because there hasn't been an exercise of a contractual right.
Well, but that equally means that change orders 2 and 3 are not under the contract.
But we are at this stage accepting that it wasn't under clause 12 of the contract.
I'm sorry, if you're saying that change order 1 was not under the golden contract, but constituted a new contract, which is the only alternative, equally that must apply to change orders 2 and 3 as well.
That's a fair point. I think my point is this. If change order 1 wasn't under the golden contract, wasn't a variation within the golden contract, then what happens is a question arises as to whether or not change order 1 could have been under the golden contract. But I think my Lord's point is...
We don't have the material to look at that at all, because it raises all these points about how different is a data center from a microchip factory.
That's exactly the point we've been discussing in the context of change order 2.
No, it's not. The point in change order 2 is the very point you're on now, that this is that change order 1 had already exhausted the rights under the contract. That's the real point. We're not really delving into issues as to whether the building being up 20 yards or meters away from sites, all that stuff. I mean, that's just not really relevant.
That arises in clause 12.1.1 under the contract.
No, I don't think it does, actually.
Yeah. Okay, I don't need this point, and I'm not going to use up my time on a point which is apparently not going down very well. So you've got the first point we make about that. And in a way, that's enough for us. I want to move on, if I can, to deal with...
I'm so sorry, just on that. The first point which you say is enough for you is what? That it hadn't, DC1 had not, in fact, been constructed.
The first point that I'm making...
by the first point, which is enough?
If the point depends upon the completion of the building, then, as a matter of fact, that was wrong.
Right.
Because the building hadn't been completed. I need to deal next with the way in which Lord Justice Newey puts it, which is that if you've exercised the contractual right, that is it, you can't vary it.
Right, okay.
Because you've exhausted the right.
Yes, and arguably that's how Lord Justice Lewison put it, depending on how one reads
Arguably, that is what he said as well.
Okay, thanks, Hans.
Now, we respectfully submit that if you are looking at the point simply on the basis that I exercised a contractual right and I therefore cannot vary it because it is spent, we respectfully submit that merely exercising a contractual right cannot involve as a corollary that you can't vary that which was contained in what you've instructed the person to do. That is to say, we're taking away the possibility that the work's completed. We're just looking at the exercise of a contractual right. If I illustrate that with an example, I'm offered by some developers a opportunity to buy a new home in Surrey or somewhere. One possibility is of a house with a swimming pool. Another possibility is of a house with a tennis court. And I say to the developer, please can I have the one with the tennis court? And I exercise that right. Does that mean I cannot vary that contract by saying, actually, can you add a swimming pool to that as well?
But that's not what they did. They've still got DC1. It did get completed.
But it wasn't completed at the time that the variation
No, but
was
you
introduced.
weren't asking them to knock it down and do DC2 instead.
But in a sense, that's what my example brings out. Let's say I say to a developer, I have a plot of 4 acres. Can you put one house? And he says, well, I could build 1, 2, or 3 houses there. What would you like? I say 1 house. He starts building the 1 house, and I say, actually, I'd quite like, rather than just the 1 house, can you do 2 houses? The question is, is there any difficulty in saying that that is a variation of the original contract? Because in my respectful submission, as a matter of law, I cannot see why, with respect, there is any difficulty in saying that just because I've exercised their contractual right in that way, I cannot thereafter vary the nature of the contract with whoever it is I'm contracting with.
Was DC1 ever fitted out? Because I think at the time of the upper tribunal hearing, it hadn't been let. And I think fitting out was intended to be in accordance with the tenant's requirements.
That sounds like it may be so. I'm getting nods from next to me.
Right. So this would be the ability to require further works or to vary could be going on for years. On this
And with respect, that may be so. But
Yes.
so what?
Okay.
With respect, if I can put it that way,
All right.
is there any legal reason? Is there any reason of
Yes.
the common law which says that in that situation you simply can't vary? And in my respectful submission, there isn't.
So it really goes back to the earlier point. If it's only a matter of their intention and not looking at how different the next contract is.
Exactly.
However different you might think a contract to build 2 houses rather than 1 house is, if that's what they've varied it.
Exactly. With respect, exactly. Can I put the point in this way? I'm not saying that the fact that there has been an exercise of a contractual right, be it my house in Surrey with a swimming pool and a tennis court, I don't have one, or what was happening here, I'm not saying that that can't be relevant to the consideration of what the parties objectively intended. I don't say that, because you have to look at all the circumstances of the case. And one circumstance may be, if we can go back to my Lord Richard's example, of let's take the trip to Paris followed by the trip to Brussels. If I've already been to Paris and we don't expressly agree to vary, that it's a variation, and you just look at what has happened, all the circumstances, and you just have a trip to Paris and say 2 years later a trip to Brussels, one can quite see it'll be quite difficult to say that's a variation, that's what the parties intended. So I'm not saying that it doesn't have any weight in the consideration of intention. But it's not, well, one needs to get the facts right here. And the facts are, yes, we'd said do X, and we then changed it. The facts are not that the work had been done. The work was half complete, or a third complete, if you look at the costs involved. In my respectful submission, as a matter of law, there really is no reason why you can't vary something even if the work has been 90% complete. I can see that when you get to 100% complete, you may say, well, is that really a variation? My respectful submission, it can be a variation. I could ask the developer who's built my house in Surrey with a swimming pool. He says to me, look, I'm about to finish. Is that okay? You want to get the keys? And I say, but before we do finish, before you hand the keys over, I'd like a sauna bath. Can we just add that on, and I'll make it a variation to this contract, and I'll pay you for that? With respect, what is wrong with that as a matter of law?
Can I just say this? I may be wrong about this, but I don't think that, I'm not sure that change order 2 varied change order 1. It's not,
No,
I can understand, I think what...
No, I'm not saying it did.
Right?
I'm not saying it did.
No, but I think that the analogies you're providing are rather tend in that direction. So in other words, it's sort of adding something to DC1. But actually, DC2 is a quite separate undertaking. So I'm just not sure that the sort of, as I say, the analogies quite fit.
I'm trying to respond to what the court said, which is that the exercise of the right to go with building DC2 or works option 1.
I mean, the sort of things that you're talking about could almost certainly be accommodated by clause 12.
Well, and in my respectful submission, as you know, I said they are accommodated by clause 12.
But we're not on clause 12.
But I'm not, I mean, we can laugh about it, but actually, the nature of the changes that were made were not significant.
But they were quite different to what was in change order 1, because it was a completely new building, quite separate building.
That is true, but why does them being different to change order 1 matter?
Because the contract provided for one option to be exercised.
And before that option was concluded, I said I'd like another building.
I'd like to exercise another option.
Yeah.
Yeah. That's what happened.
Well, no. With respect, what actually happened was it said, we've given you works option 1 and 3. We want to vary works option 1. So I'm not giving you another...
Is that actually what...
That is exactly what happened.
Okay. That's in that, we can see that.
You can absolutely see that if you look at... You can see that if you go through the change order. Change order 1 said works option 1 and 3. This is an instruction under works option 1 and 3. And it actually said we may issue further things which vary works option 1, or works option 3 and 1. And then what subsequently happens is they vary works option 1. So with respect, I'm not sure what your Lordship puts to me is right.
Well,
So you're relying on the heading works option 1 for the change order? For that?
I'm not relying on it because, but it certainly was a change to works option 1. Yes.
Yes.
Yeah. That's certainly what the heading says. Yeah. Unless your Lordship and your Ladyship want to ask me further questions about exhaustion, I am going to move on, if I can, just because I have to deal with, and I'm running out of time fairly quickly, I need to deal with the third of the points. But can I just say in relation to the exhaustion point, this was, if you read Lord Justice Newey's judgment, which in our respectful submission comes closest to being the correct position, except that he jumps the wrong way at the end. He jumps the wrong way at the end because although he accepts that the intention point in relation to tax matters, he in his judgment considers that's outweighed by the exhaustion point. And in our respectful submission, when you look at the exhaustion point carefully on the basis of the facts and on the basis of submissions, because as I say, it came up in argument, it wasn't really dealt with in the way that it's been dealt with here, the exhaustion point or the spend point doesn't really work. And if the exhaustion point or spend point doesn't work in the way in which Lord Justice Newey thought it worked, possibly because he misunderstood the facts, then all he would have had left, which is a point in our favour, was the tax intention point. I need to finally deal with, before I get on to issue 3, with the SDA point. The SDA point, with respect, is a curious point. It is mentioned by Lord Justice Lewison as being relevant to his conclusion. It's not clear how or why. He simply says the parties had in contemplation at the time of the change order 2, the SDA, and as I say, it's not clear why it matters. My learned friends for the commissioners rely on the SDA point in a different way. My learned friends rely on this, and I understand why they're trying to do it in a different way, but this also doesn't work. They want to say that this other contract, the SDA contract, was in fact the contract under which the expenditure was incurred. And if that were right, that would be a silver bullet to our hearts, because then we couldn't say the expenditure was incurred under the golden contract as varied, because the expenditure would have been incurred under the SDA. And so one at least understands the relevance, to their case at least, of the SDA point. With respect, although they've got the right legal point to run, it is hopeless. Because the suggestion, if that is what they're saying, and I do understand that to be saying, it's paragraph 106 of their written case, page 101, the suggestion that the expenditure was under the SDA is belied completely by the facts. If you go to paragraph 30 of the Court of Appeal judgment.
Did you say 30?
30.
Yeah.
I'm just trying to get a reference to that. Page 123.
Sorry, I missed your page number.
Page 123.
Thank you. Yeah.
Now, just chronologically, the court will recall that the change order 2 was issued on the 1st of April 2011. And if you look at paragraph 30, you will see that on the same day, the expenditure was paid, the payment was made. It was made by the developer to the contractor. So on the same day as change order 2 is agreed, the contract sum is paid. The SDA was only entered into 3 days later. If you look at paragraph 32, you'll see 3 days after the issue of the change order number 2, on the 4th of April, the SDA was made. So that was 3 days after payment under the golden contract, as they thought they were paying, was made for the expenditure in respect of change order 2. That being so, as a matter of fact, it is simply impossible to say that the cost of the expenditure of change order 2 and what was built under change order 2 was something which was made under the SDA as opposed to being made under the golden contract. But that isn't all, as if that weren't enough.
So you say it's a simple timing point. The contract sum is payable, or sorry, is paid 3 days too soon for the HMRC case.
It's certainly a simple timing point, but it's reinforced by what the parties actually agreed. If I can ask you next, please, to look at the SDA itself. You will find that at page 693 of the document, so core bundle 2, page 693. So it begins at page 656. It begins at 656. Is the
begins at 656.
Yeah. And in fact, I was going to, perhaps I can take you to, if you've seen where it begins, just take you at page 668 to paragraph 2.5. Because it's not only the facts that we've seen. If you look at paragraph 2.5 on page 668, you see this: the developer has, prior to the date hereof, paid to the principal contractor the sum of 54 odd million, being the total amount due and owing by the developer to the principal contractor pursuant to the principal contract. The principal contract is the golden contract. So the parties to the SDA, not only do we know as a matter of fact that it was paid, but the parties to the SDA have agreed. And then if I can invite you next to go to clause 19.1G on page 693. These are warranties. They begin on page 692. So the developer warrants and represents and undertakes to the owner as possible, as follows. And then G, that all expenditure which has been incurred by the developer in connection with the property, the building or the building works, has been or shall be incurred under the contract referred to in clause 19.1E. That's the golden contract. So not only do you know as a matter of fact that the expenditure was paid for under the golden contract, but we have these contractual provisions which further reinforce that point. Now, I don't have time to take you through the SDA to show you the provisions. What I would just say, and the court is, if it is concerned about this point, I would invite you to look at it, because what it is that it is a contract under which the building is sold. It is not a contract under which the building is built. The contract under which the building is built remains the golden contract. The contract under which that building is sold is the SDA. And the expenditure is incurred under the contract under which the building is built. And that is all I was going to say about the SDA. It really goes, well, if it doesn't count for the purposes of whether the expenditure was incurred under this contract or that contract, then in our respectful submission, it really is of no relevance at all. And it really doesn't help my learned friends in terms of whether it is the contract under which the expenditure was incurred.
Was the contractor a party to the SDA?
Yes, he was. Now, that I think...
I hear what you say, but there are clauses that, on your analysis, look at least odd. Can I just show you 14.7 on page 482, which says the principal contractor shall, at its own expense, carry out or procure the carrying out of the shell works and the fit-out works. What's that? What does that mean?
14.7.
7. The principal contractor shall, at its own expense. Let me not delay you now if there's not something immediately in mind, but I would be grateful for help on that at some stage.
Okay, I'll come back to that if I may.
Yes, thank you.
Okay. Can I then just move on to issue 3, which is the statutory interpretation issue? The court has the relevant statute at page 1058. It's behind tab 3 of the primary authorities. And if I can invite the court to go, please, to, well, we're at 1058. So this is the provision which is an issue, the time limit for qualifying enterprise zone expenditure. For the purposes of section 299 to 304, the time limit for expenditure on the construction of the building on a site in an enterprise zone is 10 years after the site was first included in the zone, or if the expenditure is incurred, under a contract entered into within those 10 years, 20 years after the site was first included in the zone. So the time limited for expenditure, primary case, it has to be 10 years after the site was first included in the zone, or if not that, if the expenditure is incurred under a contract entered into within those 10 years, then the expenditure has to be incurred within 20 years after the site was first included in the zone.
So Section 5 defines when expenditure is incurred, that's page 1050,
Yeah.
when the sum becomes unconditionally due. So that looks as though the primary case is the building's actually been built, because that's usually when you would expect the sum to be unconditionally due. Is that right?
That is the primary case. The primary case is the A case. If I can put a subparagraph A, the building will be built. And that's why, as my Lord says, the primary case is the first period, the first 10-year period under 1A. The question that separates the parties is whether, when you go to B, you should read B as being, so for the purpose of these sections, the time limit for expenditure on the construction of a building on a site in an enterprise zone is if the expenditure is incurred under a contract, Malone and Friends want to read in, for the construction of the same building as eventually built, entered into within those 10 years, 20 years after the site was first included in the zone. So what Malone and Friends want to say is that B is only operative if the expenditure is on the construction of the same building as the contract provided for at the outset, which effectively I think means you can't have variations.
And I think they say the same site.
And it has to be on the same site. Now, I think the first point to make, if I may.
And they mean as prescribed by the contract by the end of the 10-year period, presumably.
Indeed. So they basically say everything has to be
contract you made in year 5 and amended in year 9, but you could rely on the amendments.
That is it. That identifies there has to be an obligation which arises in respect of a particular building, and if the building is not, I mean, they say the same building, but they somewhere say it doesn't have to be exactly the same. That's the point we'll come to. They say you are out with the section.
I mean, it would be incurred under a contract for the construction of the building, which would refer back to a building at the start.
Indeed, for the building, being the building.
That could accommodate variations, I dare say, to the building, provided it was properly described as the building.
I think
I mean, extra windows in the house, or even the addition of a swimming pool.
They would say that's the same building. I'm sure they would say that's the same building. Now,
so do we read it as effectively substantially the same building to allow for latitudes of some design changes?
Well, you'll have to find that out from a learned friend, because they say...
But I was asking you, you seem to be acknowledging that there is some latitude.
Because they say the same building, and later on they acknowledge it doesn't have to be in all respects identical. So they'll have to explain what that means and how you test that. But in answer to my Lord's point, it seems to be the same or broadly the same building. Now, it is, we submit, important to emphasize that this question arises on the footing that we've prevailed either on issue 1 or issue 2. In other words, we're in a situation in which one accepts that as a matter of the common law of the contract, we were able to vary the contract so that what is being built is under the golden contract, because it's a variation of the contract. The commissioners contend that even on that assumption, that's to say, even if we are able to vary the golden contract so as to build additional building, different building, they say the time limit in 298 is not satisfied, 2981B is not satisfied, because, as I say, they say the words under a contract, although unqualified here, should be read as if they said, under a contract for the construction of the same building as that eventually built. Effectively their case. And that is at paragraphs 15 and 19 of their case at page 68. They further say that DC2, even if it was as a matter of contract law, built under the Golden Contract, is as a matter of fact not the same building as that provided for in the Golden Contract as originally drafted. Now, as the court knows, we respectfully submit that the Commissioner's construction section 298(1)(b) is simply wrong. Can I first just show you what the Court of Appeal said about this? Because, as you know, the Court of Appeal decided this point in our favour. You will find this in the judgment of Lord Justice.
Exemplary brevity.
With exemplary brevity. Sometimes when things are plainly right, they don't take very long to say. If I can invite you to go, please, to page 124. The court deals with this point beginning on the previous page, paragraph 38. So on page 124, if you're there, paragraph 38. They set out the provision, and just picking up at paragraph 42 and 43 and 44. I'm not sure I need to take you to that because the essential reasoning is at paragraph 45 and 46. Lord Justice Lewison and in this the other two Lord Justices agreed. I do not consider that this argument carries the day. In my judgment, the questions to be answered under section 208 are, and he's obviously picking this up from the statute, has expenditure been incurred? Question 1. If yes, has it been incurred under the construction of a building? 3. If yes, is the building on a site in an enterprise zone? If yes, was the expenditure incurred under a contract entered into within 10 years after the site was first included in the zone? And if yes, was the expenditure incurred within 20 years after the site was first included in the zone? And 4 and 5 are 1 and A and B. And in our respectful submission, that is exactly what the language of the statute provides. He then says this: the legislature does not mandate any particular kind of contract, and the exercise of answering these questions is a retrospective one, looking back from the time that the expenditure is incurred. The drafter of the Act was alive to the question whether expenditure has been incurred, as shown by section 5.1. By contrast, section 298 is not concerned whether expenditure has been incurred within the 10-year period as opposed to the 20-year period, but only whether a contract has been entered into within the shorter period. I agree with the upper tribunal's conclusion in paragraph 117. Nevertheless, Mr. Williamson, who presented this part of the argument, accepted correctly in my judgment that the contract under which the expenditure is incurred must be the same contract as that which was entered into within the first 10-year period. It could not, for example, have been Parliament's intention that parties could enter into a contract within the 10-year period to construct a building in an enterprise zone, complete construction in that period, and then 9 years later purport to vary that contract so as to agree to construct a second building. That leads to HMRC's second argument, which is the argument we've just been considering. In our respectful submission, there are 4 points that support our conclusion. We say first that the Commissioner's construction is contrary to the language of the provision. Second, we say the Commissioner's construction produces a result that is contrary to the purpose of the provision. Third, we say that the predecessor legislation on which the Commissioners rely, even if admissible, does not support their construction of the present legislation. And we do say it's not admissible.
You do say it's not admissible.
We do say it's not admissible. And fourth, we say that the construction for which the commissioners contend is largely founded upon a false premise, namely that our construction produces absurdities, which we respectfully submit it does not. In a sense, produces results contrary to the purpose of the statute. And perhaps I can address these points in turn, turning first to the language of section 298(1)(b. Court has, as the court sees, it says that the time limit is satisfied for expenditure incurred after 10 years if it is incurred under a contract entered into within those 10 years.
But if you look at the variation, that's a contract entered into outside those 10 years.
With respect, no. The contract, if you treat the variation as a separate contract, then it is entered into outside of those 10 years.
Which it is, as a matter of contract theory.
With respect, as a matter of contract theory, it takes effect as a variation to the original contract.
Right,
the expenditure which is incurred under the original contract as varied.
Right, but the variation is itself a contract, isn't it? Isn't that how you effect a variation?
Which as we know, because this court didn't deal with the issue in a recent case, still requires its own separate consideration. A variation of itself to be effective contractually requires consideration.
I understand that. The point that my Lord Sells is putting to me is in fact the point that was rejected by Lord Lord Devlin in the Shuker case. As a matter of pure logic, the way my learned friend my Lord puts the point to me, I'm sorry, is correct. As a matter of pure logic, it is a new contract.
Right. I mean, Shuker wasn't concerned with this statutory regime. We have to apply this statutory regime.
That is true, but what my Lord was putting to me was that we have a new contract under which this expenditure was incurred, and I'm saying that that is not how the law regards variations. When you have a variation of a contract, you don't treat it as a new contract. You treat it as a variation of the old contract, and if expenditure is incurred under that contract, then it is incurred under the contract as varied rather than under a new contract.
Yes. I mean, I think I was putting to you that, potentially there are two contract candidates here. I mean, I can see that you can say that it's a variation, and therefore, in some sense, the original contract continues to have contractual force. But might it not be said that the specific contractual force on which you're seeking to rely stems from a new contract made after the relevant period?
The specific contractual force?
Yes. I.e., people are required under a contract to construct DC2 and DC3.
Well, it may be that it goes around in a circle, because my response to that would be, it is true that the obligation to construct DC2 arose as a result of what was agreed by way of a variation after the 10-year period. Yeah. But because it's a variation, the expenditure that is incurred under the contract as varied.
You're assuming for these purposes that you've won the first two arguments, and in doing that you have put to one side or put to bed, I don't think you specifically mentioned it, but the way in which the Court of Appeal ultimately concluded that this was a new contract as opposed to a variation. But you say if you win on the variation point, if we ask, when is a varied contract entered into? The answer is it's entered into when the original contract is entered into. We don't say the varied contract becomes a new contract entered into 5 years later.
Exactly.
We retrospectively push it back.
Exactly.
I think that's your point.
That is my point.
Yeah, but the point against you is we're construing this statute, and what did the statute mean when it refers to an obligation being entered into within 10 years?
It refers to...
actually mean, as long as you can find a contract entered into within 10 years, you can vary it for however long you want, and any expenditure on the additional bits is still incurred under a contract entered into within those 10 years? That's the question.
No, indeed, that is the question. So the question becomes...
But it's not generally contract law that a variation is retrospective in its effect. For example, if I enter into a lease with a certain kind of repairing obligation to paint every 2 years, every 7 years, and then I vary it 10 years later, so I have to paint every 2 years, I'm not in breach of the lease because I didn't paint every 2 years up until then.
That may be so, but if you...
I mean, generally speaking, I would have thought that the effect of a variation is absolutely not retrospective unless the parties pretty expressly and clearly provide that it should be.
With respect, I'm not sure that the issue is whether it's retrospective or not.
Well, you raised the word retrospective there.
I think it was mine.
No, I don't think I did.
I apologise.
I don't think I did.
I wasn't intending to suggest that the obligations in that sense became retrospective.
No.
I only meant at what date does the contract is regarded as entered into. It doesn't. There's no new contract, as I understand it, entered into at the date of variation. There's just one contract which was entered into at the start.
Forgive me, I thought it had been accepted that the variation was a new contract. That's how you affect a variation. Sorry, that's what I had understood Mr. Rabinovitz to accept that.
No. But the point which was made in Shukar by Lord Devlin was that you could, as a matter of pure logic, effectively say every time there is a variation, there is a new contract. Yes. But he rejects that as being the correct approach, and he says that the way in which it was dealt with by the House of Lords in Morris and Bennington's was not to say that, but effectively to ask whether what was agreed, I'm not going to call it a new contract because it gives rise to the sort of debate it gives rise to, whether what was agreed took effect as a variation of the original contract, not that there was a new contract. Now, I entirely understand how you can say, in order to find what was agreed, there has to have been a new agreement.
Thanks. That's what I understood. Yeah.
Right.
I mean, the point would be illustrated only. You could easily have a case of a contract which the parties wish to vary, and they enter into a supplemental agreement varying the original agreement. So you'd actually have two documents. Document one is the original contract. You then have a supplemental agreement dated the later date, whereby the first contract is varied. The question would then be, for these purposes, is the expenditure incurred under the original contract as varied by the subsequent contract or under the variation contract? I mean, it just illustrates the point only. It's the same point.
Yeah.
But if you get back to section 2981B, bearing and think purposively about the 10-year limit, why is subsection B not answered by looking at the contract relied upon at the end of the 10-year period to see whether at that stage it provided for that expenditure?
Because that's not what it says. The focus here is on the expenditure. It says, for the purpose of section 298, the time limit for expenditure on the construction of a building is 10 years after the first was included, or if the expenditure is incurred under a contract entered into within those 10 years. Yeah. And the question, as Lord Justice Lewison saw it, was what are the restrictions here on that contract? This provision has no restrictions on that contract. Now, I know and I accept that we're going to get into a discussion about, well, what about a sale of goods contract, can you use that? And I will, if I may, come to that. But just looking at the language, in my respectful submission, the language does not introduce any restrictions on, we're going to move on from this, but the language does not include any restrictions on the contract, what it has to be, and whether it has to be for the same building, which is what's being suggested, so as to exclude any variations in relation to the building, which might give rise to a separate, different expenditure.
Can I just ask you then about the point at which B appears in the context of this provision? Because you yourself described A as the primary case. Now, under A, you get maximum certainty within the initial 10-year period of the enterprise zone. You've actually got a building, more or less, constructed there. The point, as I understand it, of enterprise zones is to attract in other investors as well, to get regeneration off the ground, so that people can see, other people, the market generally, can see that there's a building there or something else is going to be there, which is B. Now, if in A you go for complete certainty, essentially a building has been built already, isn't B a form of extension of that? And one would expect a high degree of certainty, as at the end of the 10-year period under B, signalling to the market what is likely to be in the enterprise zone within a reasonably finite period of time. Now, if that's right as a way of looking at it, doesn't that tend to support what my Lord Briggs was putting to you, that one would read the words in B as incurred under a contract entered into within those 10 years as looking to the essential building obligations already being in existence at the end of that first 10-year period?
Can I just go back to your start with respect to your starting point, which was what the point is of these enterprise zone provisions and the 10 and 20-year time limits. Yeah. The point of the enterprise zone was to bring about regeneration of these units by ultimately encouraging people, because they're being promised allowances, to build buildings in a reasonable period of time, which would attract workers, which would create jobs, and which would return what was otherwise an industrial site not being used into a site which was being used. This is to jump to a slightly different point. If my learned friends are right, this will have exactly the opposite effect, because what you're contemplating is that in year 2, let's say enterprise zone year 2000, 2002, someone thinks, and they label this building, a building to produce vinyl records, because in 2002 those things existed and everyone cared about them. 10 years later, no one cares about vinyl records. Let's say that in order to produce vinyl records, you need a factory which is slightly different to a factory which is going to produce iPods or some other device for delivering music. You can take any number of examples. Mechanical diesel cars versus electric cars. So in the first 2 years after the enterprise zone is established, someone thinks, let's build a motor manufacturing plant to produce petrol vehicles. They start getting planning permission. Planning permission takes a while. After 10 years, they're actually told that you can't get a petrol car because that's really bad for the environment. But if you built a car to produce electric cars, well, that would be jolly, and it would attract a lot of work, and will give you planning permission in a week. That can't be built because you wouldn't get allowances because the building is different. That's the consequence of this. Over this period of time, 20 years, technology changes, the nature of buildings change. What is given permission to be built by planning permission will change. The demands will change. The requirements of producing even a plant to produce these boards which were being produced would change dramatically. And the shape of the building, it may be a completely different building. That wouldn't get built. It would completely undermine the whole purpose of this.
Why, in that case, does it require the contract to be entered into within the 10 years?
Because there has to be some commitment, i.e., so take our situation where you have an obligation to build some building. They know you're obliged to build a building, but if the building that is built is different, you still have the commitment that my Lord Sales put to me, necessary to ensure that other people know you're going to build something. But why does it have to be the same building? Why can't it be varied?
It's not just the same building, it's additional building.
Whatever it is, it doesn't matter.
When you've got a building contract within the 10 years, you can add on as much as you like, provided it's a variation.
That exactly achieves, in fact more than achieves, the object of the statute. You'll have 10 buildings rather than one. Why is that an absurdity?
But that you would achieve by having a contract entered into in year 11, provided that
you could vary
within.
Well, let's say you have a contract within the first 10 years for 2 buildings, and in year 11 someone says, you know, I'll build this is such a go-go industry, let's have 4 buildings. I won't build them because I can't get any enterprise allowance for it, so I won't do it, and the enterprise zone doesn't do as well as it would. Why is that consistent with the purpose here? Why does it have to be the same building?
What do you say is the significance of the first 10-year period referred to in subparagraph A?
Isn't that the original period? It was, because the statute originally had 10 years, and then it was extended to include, I think originally no limit, and then someone said, well, no limit's ridiculous, let's make it 20 years.
I mean, might it not be said that it's indicative of the fact that enterprise zones don't last forever? They're intended to be sort of seeding redevelopment.
With respect, I don't have any difficulty with that at all. This is intended to build things relatively quickly, but it allows for the fact that things change over a long period of time. And in our respectful submission, if you start constraining the nature of the contract, so it has to be the same building, you completely undermine the purpose of this. You don't achieve the purpose. You're very likely to say, okay, if it's 2 windows, then it's the same building. But what if I'm building an outhouse or something else? Then it's a different building and you can't get allowances for something. Why would anyone want to do this? If it's 3 times the size, is that still the same building? If it's 10 times the size, is that still the same building? Why would it achieve the object of this legislation?
Because it might be said, what is sought to be achieved is signalling to the market within a 10-year period.
But
That's A. You will get maximum signalling in terms of certainty to the market that there will actually be buildings built if you go for a contractual obligation which is in place at the end of the 10-year period. And you are incentivized to do that because you will get your EZAs if you do that in time. And if you say, well, perhaps it would be good to cover oneself against changes in technology and so on. And you can do that. It's just that the risk will be on you. You can put in for a number of factories at the outset and only proceed with some of them as you go forward.
With respect, why would I take that risk? Your Lordship identifies some factor which would be a good reason to get people to do it within 10 years. I accept that.
So it's a trade. Well, I would have thought that an enterprise zone is a trade-off between tax benefits that you wouldn't give to people generally, but you're doing it to promote a specific aspect of the public interest.
With respect, you are doing it in order to encourage building in a particular area, which will attract jobs and transform a particular area, just in the way that Docklands has changed.
Can I intervene briefly, wearing my referee's hat?
Sorry.
To point out that I'm afraid we've dragged you on beyond your time.
I'm sorry.
Of course, we know that you can always take a bit off your reply time and add it on now.
Well, I think I'd
I'm quite anxious that you get a chance to say anything new that you want to say, even though you're doing that.
I think if I may just take a few minutes just to deal with the purpose absurdity point. I would just say, in response to my Lord Sales's point, I'm sure there were reasons why it was a good idea to encourage people to say the maximum investment possible in the first 10 years. And it was perfectly possible that if that's exactly what the revenue had, what the legislature intended, they could have said that, but they don't. And so the first point is, because there are reasons the other way around. There are reasons not to lock people into a single building. There are reasons to allow for the possibility of technology producing changes. There is no good reason why you wouldn't want 2 buildings rather than 1 building. In fact, that's exactly what you want to achieve. So you can think about reasons why don't narrow this down, expand it as much as possible. And in the end, we're left with the language which is used, which doesn't constrain the contracts at all. Now, I'm short of time. I'm going to move on. I'm going to deal very briefly with the second of our points, which is I've already made the point that the predecessor legislation isn't admissible.
Yep.
Because in our respectful submission, there's no really substantial difficulty with this, and there's no ambiguity. But even if you did take it into account, and learned friends rely on, I think, Section 74(1) of some earlier litigation, it gives legislation. It gives rise to exactly the same issue. It doesn't actually help. You're still deciding exactly the same points, and with respect, there's no point in going there. This language is clear, as Lord Justice Lewison found. The other point I think I need to deal with is I'm going to call it, well, I've dealt with to some extent the purpose point. Why is this in line with the purpose? In that context, I just need to touch on what my learned friend says are absurdities. And he identifies 3 absurdities, and if I can deal very quickly with them. The first absurdity is you agree a contract for, I think, 5 million in EZ1, and you land up building 100 million worth of buildings in a different enterprise zone, can that really still be within? Is that an absurdity? In my respectful submission, that achieves exactly what this legislation was intended to achieve. The fact that you're building more isn't contrary or absurd. It's exactly in line with what was intended here. He gives another example about, well, if we were right, you could vary this as many times as possible and build as many buildings as you like. Same answer. With respect, there is...
Except that only the first buildings are supposed to get the enterprise zone allowance. If people then build more buildings, then they don't get the allowance.
But that's not what the statute says.
They're incentivised by the fact it's already a zone.
You have to incur the expenditure within 20 years. Those are the first buildings. If you incur the expenditure within 20 years, then you've done what the legislation wanted you to do. You've created a new reality in a particular area. I just need to deal with a third point, because in a sense it's the best ambiguity point. They say, well, does this mean you could enter into a sale of goods contract and later transform it into something else? Well, I mean, one answer to that is to say that is so beyond the realms of what we're talking about here. You'd have to get that to qualify as a variation anyway. And it's conceivable that it would first have to be between someone who wanted to develop and someone who would want to build. Secondly, if it wasn't between them, or even if it was between them, you'd have to accept that there was a variation rather than a new contract. And thirdly, if there was a new contract, which was once, for example, for paper clips, but is now to build 10 industrial units in some enterprise zone, then in our respectful submission, you can limit this by saying that the legislation would only apply to a contract for building in an enterprise zone. In other words, not any contract, not a contract for the sale and purchase of fish and chips, can suddenly be transformed into a development contract. You could limit it to contracts which are concerned with building in an enterprise zone. My learned friend's additional words with respect...
Same enterprise zone or any old enterprise zone?
Well, with respect...
Doesn't matter in this case?
It doesn't matter.
No. Okay.
It doesn't matter. My point is this. The words that you are required to avoid their third absurdity are very easy to find, and they're much, in a sense, less restrictive than the words my learned friends identify. The only reason to go as far as my learned friends go in terms of the restriction is to enable them to succeed in this case, and perhaps to stop paying all the people who are queuing behind us for allowances to succeed in their cases against the expectation of the market for years and years and years. That's not necessary. That kind of restrictive language is not only inconsistent with the purpose, not founded in the words, and not necessary to avoid absurdities. It goes far beyond that, and in our respectful submission, achieves an outcome which is completely inconsistent with the purpose, and indeed with what you would want to do, because it doesn't allow for changes in technology or anything else to be brought into effect. And if that's the position, you're going to have a lot of white elephants, because people say, I'm not going to do this, I don't get an enterprise zone allowance, I'm just going to stop building now. I'm not going to deal with the procedural points because I've run out of time, but...
Well, we've got it in your written case.
You've got it in our written case. Unless I can assist you further.
Thank you, Mr. Rivett. I'm sorry we've given you such a hard time,
No,
but it's been a very helpful discussion as far as we're concerned.
Thank you.
Mr. Stewart.
In the few minutes we have left, I was going to deal with a few preliminary points and then give you a roadmap as to where, how our argument is structured. The first point is an administrative point, something that was raised right at the beginning. I asked the same question, I think, as some of your lordships, which is, could I have a version of clause 12? And Mr. Cosman has very kindly done that for me, so I'm very happy to. I was thinking, should I make use of it? But it sounds like it would be very useful.
Please send it to us electronically.
I'll send it. Yes,
when it's been agreed with your.
Yes, yeah. I think it's all fine, except I think there is some confusion as to what's meant at the end of the clause, but it's not relevant to the case. But I'm sure it can be agreed quite easily. So we'll send that to you. Secondly, can I just say generally, you will not be surprised that we do not agree with my learned friend's characterisation of the scheme in this case. However, as I think the court recognised, that's not relevant to the issues that are on this appeal. It had some relevance, to other issues, some of which may or may not still be live depending on the decisions. But we certainly do not agree that this is a straightforward commercial transaction. We may touch on some of the oddities of it tomorrow. Can I then give you a roadmap of where I intend to go tomorrow? I was going to start by dealing with the point of construction, which you've just been discussing, of Section 298, because obviously that is the context in which all the other arguments have to be made. And then I was going to deal with the Clause 12 argument and what it permits the employer to do. And what I was going to deal with there was not just how it does not provide for different works with a capital W, but also, very importantly, it does not provide for changing the nature of the contract from a single building contract to a multiple contract. I shall then go on the basis that we're right on Clause 12 and that what happened was the employer attempted to effect a unilateral instruction which failed. However, all of the parties, in particular the developer and the employer/developer and the contractor, all believed at the time, and indeed I think still possibly believe, that instruction was valid. And that was, of course, you have to understand, that was the basis on which everything happened after the instruction was given. The parties believed that there had been a valid exercise of a unilateral instruction. So what I was then going to consider was the correct analysis of the situation on that basis. And in doing that, I will be dealing with the exhaustion point, which was discussed this afternoon, and indeed the impossibility of exercising Works Option 1 repeatedly. When after it was exercised once, there was a building already on the site. But most fundamentally, I will be dealing with the difference between this case and all of the cases on variation/rescission, which you will see, which is that we say in this case there was no bilateral agreement between the parties to alter, I'll use a neutral term, to alter the contract. And I want to deal with that point, because in my submission that's very important. It seemed this afternoon as if my learned friend was essentially saying, because there had been a failed exercise of the unilateral instruction, then you can and ought to construe that as being a successful variation based on the supposed intention of the parties. And we say that is a fundamentally misconceived approach. I think, as my Lord Sales said, in order for there to be a variation, there has to be a contract. There has to be offer and acceptance and consideration. But certainly there have to be two parties agreeing to it. And that's not, we would say, what happened. Now, the significance of the sale and development agreement, note, sale and development agreement, as we shall see tomorrow, it has many, many terms about the construction of the building. The significance of that, we say, is if you get to the stage of concluding that there was an ineffective exercise of the instruction, then you must ask the question, well, I think my learned friend asked the question, was there a contract under which this building was built? And we say there was. and it was the sale and development agreement. And it provided all the terms that were necessary. Indeed, it regulated. It was going to be necessary to have it in any event, no matter what the variation had been. There is, of course, the other wrinkle in all of this, which my learned friend didn't mention, which is that the terms of the instruction are not in evidence. This was something that the parties were not able to find, apparently. So
which instruction are you now referring to?
The both for DC2 and DC3.
Ah.
So we have the instruction, but you will see it refers to a much more detailed document, which tells you what the instruction was in more detail. We don't have that document.
So we don't have the revised employer's requirements.
Exactly. Yeah, that's right, lady. So we've been. This case has been argued from the beginning in the upper tribunal. On the
Are you
basis
saying
that
it's missing in the sense that it was there at one time and somebody's lost it, or it was never there?
I don't think we actually know that, but nobody really knows.
Well, they must have built it according to some kind of plan. So
No, but there were requirements produced under the SDA. All of that was done subsequently. So there's plenty of you can see.
So all the detail is in the SDA?
It's in the SDA, yes.
I think this is dealt with below.
Yes.
An assumption is made
Yes.
that the relevant instructions were issued,
They were issued, but yes, sorry, but
derived from the instructions given to the subcontractor.
yes. And,
It's a bit late to sort of argue the case now on the basis that there weren't any instructions.
I wasn't attempting to
Oh, I see.
do that. I was just pointing out the fact that we don't actually have them.
So it doesn't go anywhere.
It may go into some of the arguments, but it's not a point on its own.
Okay.
The point, my lady, was that what happened in the upper tribunal was the upper tribunal said that they would, in doing the comparison between the original contract and the varied contract, they would look at what was built and assume that that was constructed in accordance with whatever it was previously.
Yeah.
But in any event, my point is, if we're right on clause 12, then the whatever instructions there were are irrelevant because they have no contractual effect. And then finally, I was going to deal with the matter on the counterfactual assumption that there was an agreement to vary and consider the question as to whether it was a variation or a new contract. But of course, it's quite a difficult question to answer. On a completely counterfactual basis, but we'll come to that tomorrow.
Well, that's a sufficient roadmap for us to think about overnight,
Yeah, thank you.
Mr. Stewart. And we'll resume at 10:30 tomorrow.